Our next speaker, Macfarlane, who will be giving the talk, The Current Marriage Crisis in the Light of the Original Creation and the Code of Canon Law. She has spent the last 11 years upholding the dignity of marriage within a culture of no-fault divorce with the non-profit organization Mary's Advocates. Bay grew up with 6 siblings in the Midwest in the United States, received 16 years of Catholic schooling, culminating in a bachelor's degree in mechanical engineering from the University of Notre Dame. Before beginning her marriage work, she was a stay-at-home mom, raising 4 children under the age of 12. The focus of Mary's Advocates is split between supporting those who are already separated and working to protect those with Catholic marriages from unjust divorce decrees managed by the Civil Forum. Those who are already separated and want to remain faithful to their marriage vows support each other as separated faithful. Their program manual, The Gift of Self, contains a marriage vows renewal promulgated by the Pontifical Council of the Family. And Bay's network also helps spouses to defend their marriages against false allegations of invalidity in annulment cases. Thank you.
We are examining the current marriage crisis in light of the original creation and the Code of Canon Law, and I am pleading that we need to implement canon law on separation of spouses, especially where there's civil courts that have no-fault divorce. In this presentation, I will describe no-fault divorce and summarize the canon law on separation and divorce. We'll explore how the annulment mentality contributes to broken families. Lastly, I'll read excerpts from diocesan authorities wherein they denied the faithful's request for help to stop marital breakdowns in particular cases. As Father Thomas Hickey also quoted our canon, I will be, listen to what Pope Leo XIII taught about the properties of marriage in his encyclical on Christian marriage, Arcanum Divinae. The true origin of marriage is well known to all, that God, on the 6th day of creation, having made man from the slime of the earth, and having breathed into his face the breath of life, gave him a companion, whom he miraculously took from the side of Adam when he was locked in sleep. And this union of man and woman, even from the beginning, manifested chiefly 2 most excellent properties, namely unity and perpetuity. Nowadays, Canon 1056 restates that the properties of marriage are unity and indissolubility. By unity, the code means spouses will never share themselves with another partner for acts befitting to the procreation of children, so long as they are both alive. Jesus taught in Matthew 19 that Moses had allowed for divorce because of people's hardness of hearts, but Jesus said from the beginning it was not so. With God's grace, we can be free from the hardness of heart resulting from original sin. As a community working to overcome original sin, among other things, we have our Code of Canon Law. I see it as providing a system to ensure justice in our interactions. The first 3 canons in the title on marriage show what makes marriage a marriage. Other canons deal with separation of spouses and the validity of marriage. These issues were not supposed to be decided and judged by the civil courts. As explained in 1880, Arcanum, Pope Leo XIII said, "Let no one then be deceived by the distinction which some civil jurists have so strongly insisted upon. The distinction, namely, by virtue of which they sever the matrimonial contract from the sacrament, with the intent to hand over the contract to the power and will of the rulers of the state, while reserving questions concerning the sacrament of the Church. A distinction, or rather severance of this kind, cannot be approved. Unfortunately, it is common to do what Pope Leo forbid, to separate the sacrament of marriage from the contract of marriage, and then give the government power over marriage. When Chancery officials tell Catholics to get divorced before applying for annulments, the Church appears to be saying that this is acceptable because the civil courts are not trying to judge whether or not a Catholic sacramental marriage occurred. To address the current crisis and examine no-fault divorce, we need to define both civil marriage contracts and Catholic marriage contracts. Both are agreements intended to be enforceable by law, wherein two parties promise to uphold certain obligations. In both Catholic legal system and the civil legal system, some contracts are invalid because, for example, in cases of fraud or insanity. For civil marriage, marital status gives parties certain rights and obligations for things like property ownership, debt, income taxes, health insurance. When either party wants to end the marriage, a civil no-fault divorce judge will issue a divorce decree upon request. The civil laws in most states only require that one party claim the parties are incompatible, have irreconcilable differences, or that marriage has irretrievably failed. In other states, they only require that one party live separated from the other for a specific number of months. If the couple has not worked out all the details of their own divorce plan, the judge will make decisions about child custody, property division, and support. In Catholic marriage contracts, the parties agree to be permanently married and open to children. They have the obligation and right to mutual help and sexual fidelity. They have the obligation and right to live together unless a morally legitimate reason for separation exists, about which I'll elaborate later. When Catholics disregard the canon law of separation of spouses and have civil no-fault divorce judges adjudicate marital disputes, we are handing marriage to the state. In civil no-fault divorce, judges and lawyers have no interest in the reasons for separation. Lawyers' fees are regularly tens of thousands of dollars. To avoid the fees, a spouse who has done nothing bad enough to merit separation will agree to a divorce. If both spouses do not agree, a civil judge will still issue a divorce decree upon request, and the judge will decide child custody, support, property division. Among those who study this topic, it is known that most divorces are forced or coerced. To learn more about no-fault divorce, I recommend the work of Professor Stephen Baskerville, the author of Taken into Custody, The War Against Fathers, Marriage, and Family. He was also a speaker at the 2009 World Congress of Families in Amsterdam. Often in no-fault divorce, a normal, decent husband is forced to live separate from his wife and children, and then ordered to pay her spousal and child support. Children and innocent spouses can lose their homes because the court will reward abandoners with half or more of the marital property. If one parent is committing adultery, the civil court orders children to live or spend overnight visits in the home with the parent committing adultery and the new sex partner. It will be important at this time to summarize canon law's approach to separation of spouses. This is primarily in Canon 1151 to 1155 and Canon 1692. Separation in and of itself is just the factual occurrence of spouses no longer living together. And ecclesiastical separation is a decree from the church. It defines the status of those who are living apart, who otherwise have the obligation to live together, whose marriages have not been proven invalid. And Canon 1060 requires that all marriages must be presumed valid until proven otherwise. For parties in a Catholic marriage, the husband and wife must live together, except when one spouse is doing something so bad that the other has a just cause for living separated. Emotionally growing apart and simple annoyances are not a basis for separation. Adultery by one party gives the other reason to live apart. Nevertheless, the innocent party is encouraged to forgive the adultery. If an innocent spouse wants to exercise this reason for living apart, he must ask for a separation decree within 6 months of learning about the adultery. If the innocent spouse does not ask for this decree, it is assumed that the adultery is forgiven and that the innocent spouse is willing to continue living together. Canon 1153 states that Other offenses that justify separation include causing mental or physical danger or rendering the common life too difficult. A spouse is not supposed to live apart on his own authority. If a spouse feels there is a reason to live apart, the spouse should seek an ecclesiastical investigation and some kind of separation decree. To interpret canon laws correctly, one must understand the interpretations in the judgments from the Tribunal of the Roman Rota and other authoritative judgments. The President of the Pontifical Council for Legislative Texts recommends the University of Navarre's exegetical commentary on the Code of Canon Law, and it says that there are 3 conditions that must apply to justify separation in cases where the common life has been made too difficult or dangerous. The first condition is that the behavior must be dangerous. It must be repeated, and separation must be the only way to avoid the danger. If there is a danger and delay, a party can live apart on his own authority and define his marital status with an ecclesiastical decree thereafter. Remember, a separation decree defines the status of spouses who otherwise have the obligation to live together. Jurisprudence from the Roman Rota says light injustices from abusive words or the incompatibility of personalities of the spouses which make cohabitation troublesome cannot be considered as sufficient causes to separate the spouses. However, in the civil forum, many states' divorce law use incompatibility of spouses alleged by one party as the ground for divorce. When ecclesiastical separation decrees are issued, they come from either a tribunal judge who works for a bishop or from the local bishop himself. A civil divorce decree or civil separation or civil annulment can only be sought after first getting the bishop's permission to approach the civil forum. If one spouse abandons his marriage when the other has done nothing bad enough to give a morally legitimate reason for separation of spouses, the Tribunal of the Roman Rota has called this malicious abandonment. Malicious abandonment has been considered by the Roman Rota to be a reason for issuing an ecclesiastical separation decree. The decree can also instruct the abandoner to reform his wrongful behavior. When the spouse lives apart, the adequate support and education of children must always be suitably provided. This is right in Canon 1154. Historically, jurisprudence normally gives the care of the children to the innocent party, where they are to be reared at the expense of the guilty parent. One Rota case explicitly said that if a party at fault in a separation, it said that the party at fault in a separation is not due support from an innocent party. As I said, a party cannot file for divorce without first having the bishop's permission, and the bishop cannot grant this permission to a party to approach the civil forum without first weighing the special circumstances of the parties. Furthermore, certain conditions must be satisfied before the bishop can give permission to file in the civil forum. One condition is that the decree in the civil forum will be in accord with divine law. The other condition is that an ecclesiastical decree of separation will have no civil effects. This is Canon 1692, Section 2. Regarding the 2 conditions that the bishop must consider before giving permission to file for civil divorce, there is more to be said, but I included it in the endnote with my written presentation. A tribunal judge can send a party to the civil forum from the start if, after getting the bishop's permission, it is known that the case concerns only the merely civil effects of marriage. It is important to know what constitutes the merely civil effects of marriage, because whatever they are, if the case concerns only them, the case can be handed over to the rulers of the state after getting the bishop's permission. If the tribunal judge believes it is okay for a party to file for civil divorce because the civil court only handles the merely civil effects of marriage, it appears he is mistaken. Civil courts purport to release a party from his obligation to maintain an intact home, and this is not a merely civil effect of marriage. so it should not be handed over to the civil judge. I argue that custody, child support, and alimony are also not the merely civil effects of marriage. The most critical part of the canon law of separation of spouses is that no one is allowed to file for a divorce without first getting the bishop's permission. And that's in Canon 1692. And in regarding that canon and that requirement, the Canon Law Society of America in 1985 shows only these two sentences in their commentary. When the consultors met in 1979 to discuss this section, it was proposed that section should be suppressed because worldwide spouses hardly ever bring such a matter to a church court. Therefore, in the few localities where such cases do come to the attention of the church court, local legislation would suffice. It was finally decided, however, to retain this chapter as a kind of restatement of Canon 1671. That's the only two sentences that the Canon Law Society of America had in their 1985 commentary. In their commentary about the obligation to restore common conjugal life, the Canon Law Society of America included this section entitled Penalties and Separation. This is for Canon 1155. There are no ecclesiastic penalties for failure to observe the canons on separation. Spouses who separate without ecclesiastical permission may not be deprived of sacraments unless one or the other enters a subsequent marriage without ecclesiastic approval. This statement is curious, to say the least, because some of those who separate may well be in a state of serious sin, even if they do not remarry. For example, one can imagine an adulterer or an abandoner would be in a state of objective grave sin. Before we had the 1983 Code, Article 126 from the Third Plenary Council of Baltimore was still in effect in the United States. It says, anyone who petitions in the civil forum without the ecclesiastical permission incurs grave guilt and is to be punished through the judgment of the bishop. While it is true that the 1983 Code derogated the punishment part of this particular law, the new code has no effect on the objective sinfulness of actions. The Catechism clearly says that divorce is immoral and a grave offense against nature, and only allowable in circumstances as defined in canon law. The Catechism uses the words grave and immoral, and Canon 915 teaches that those who obstinately persevere in grave sin shall not be admitted to Holy Communion. In 1984, the Vatican's publishing company had an article on the cases of separation of spouses in the new code that emphasized the church's role in trying to restore troubled marriages. And this article described the canonical procedure for handling cases of separation. There are too few Catholics, especially in positions of authority, willing to intervene and relentlessly discourage someone from filing for divorce. Those who try are up against a well-funded establishment of tribunals. In 2012, 62 active tribunals that covered half the population of the United States granted annulments in first instance to 98.7% of the petitioners. In 23 of these dioceses, annulments were granted to 100% of the petitioners. The total annual expenses of these tribunals is reported to be over $15 million. Incorrectly interpreting grounds for nullity is a problem that occurs in a number of U.S. tribunals, and I'll share two examples of procedural violations. I know respondents who wanted to defend themselves but had no idea where to start because the tribunal never gave them what canon law requires: the petitioner's general description of the facts and proofs that support the claim of invalidity of the marriage. This is as preposterous as being falsely accused of stealing a car, but not being told what car and on what day the alleged crime occurred. One man told me that after having been a defendant in a no-fault divorce, he was persuaded by the deacon who did his marriage preparation to petition for a decree of invalidity of his marriage. The man learned years after the tribunal granted the annulment that the tribunal had issued 2 different versions of their definitive decree. In the man's version, the argument section was 6 lines long. In the women's version, the argument section was 4 pages long, and the man was dumbfounded to learn that it was based on his alleged psychological problems caused by his difficult upbringing. If this story had been included in the original petition, he never would have signed it. Moreover, in the longer decree, the psychic anomaly was unsubstantiated by any expert psychological witness, and the tribunal judge had even quoted a civil forum psychologist who had written, "There is no persuasive evidence that the father suffers from any serious mental illness or mood disorder." Changes to the annulment process were just announced that include the option for a streamlined procedure. On September 8th, Pope Francis issued his motu proprio. The June 23rd working document for the upcoming Bishop Synod said there was an interest in making the procedures for the cases of nullity more accessible, less time-consuming, and less expensive. Regarding expense, in dioceses that grant annulments in over 98% of the cases, if a respondent wants to defend his marriage, there are virtually no diocesan canon lawyers available who have experience working on cases that upheld the marriage bond. So a respondent either has to learn how to defend his marriage on his own or hire his own private canon lawyer. Many parties defending the validity of their marriage have been financially ruined after being a defendant in a no-fault divorce. Cardinal Raymond Burke emphasizes that if properly done, the ordinary contentious process used for complex nullity cases is not terribly time-consuming. He says that it is not the process that is problematic, but the lack of trained personnel ready to execute the process, and this begs the question. Are the personnel disregarding the procedural requirements because they do not know the process, they do not want to follow it, or have been placed in the impossible situation of not having enough staff to follow it? Our organization, Mary's Advocate, sent a proposal to the 11 members of Pope Francis's commission working for annulment. We introduced a way to use technology to make the procedure more accessible, less time-consuming, and less expensive once it is set up. Our proposal could also minimize the risks of abuse and misinterpretation of the grounds for invalidity of marriage. In Pope Francis's new annulment rules, he eliminated the automatic review by a tribunal of second instance before a decree could take effect. And if this review was an incentive for judges to follow the law and interpret grounds for nullity in accordance with the decisions from the Roman Rota, then removing the review increases the risk of abuse. The new Canon 1672 removes the respondent's right to be consulted before the competency is chosen. So now the case could be judged by the petitioner's diocese even if the respondent objects. 1678, Section 2 in the new code removes the requirement for testimony to be corroborated. The annulment reforms Canon 1675 eliminates the judge's obligation to use pastoral means to try to have the spouses reconcile. Some number of marriages fail because one spouse abandoned the marriage and is unwilling to reconcile, even though the other did nothing bad enough to justify separation. And if there is any chance that an abandoner might change his mind if encouraged by the church to reconcile, it is unfortunate for the children and the faithful spouse that the judge in an annulment case is no longer obligated to use pastoral means to induce the spouses to restore conjugal living. Pope Francis's motu proprio announced a new streamlined annulment process for certain cases, and in the streamlined process, personnel who are not canon lawyers manage the collection and summary of proofs. On the streamlined track, the bishop, who may never have studied canon law, is the judge. When a bishop wants virtually all petitioners in his diocese to get their annulments, the streamlined process will enable him to achieve his goal and use less diocesan resources. For example, if a bishop believed the claim of simple immaturity in relational matters was a ground for nullity, it could be made known that the petitioner needs to make that claim on a petition and request the streamlined process, and then the bishop could himself issue the decree more quickly. Regarding the claim that simple immaturity is a ground for invalidity, St. John Paul II publicly corrected this error in his 1987 address to the Roman Rota, and it was also corrected publicly by the Dean of the Roman Rota in 2006. My hope is that we will start making honest distinctions between a party who was incapable of marriage, a party who chose to renege on his or her marital obligations, and somebody who lied or simulated when making marriage promises. These facts should be uncovered before a party approaches a civil forum for divorce, because these distinctions are relevant to determining the parameters of a separation plan that is in accord with divine law. And the bishop is supposed to consider this before giving permission for anyone to approach the civil forum. In cases of separation of spouses, the canon still shows that the judge is obligated to attempt to work towards reconciling the couple. And let me share with you what I have learned from Catholics who have asked the church for help when a spouse wanted no-fault divorce. One husband, I'll call him Felix, told me about his experience. When his wife became unhappy in their marriage, she told Felix that she no longer loved him, liked him, or even respected him. According to the wife, the associate pastor told her if she had done everything she can do, then she should divorce Felix. Felix says there is no way he was doing anything bad enough to merit separation of spouses. And Felix wrote to the diocesan offices describing his concern about the associate pastor, encouraging separation, divorce, and telling his wife that she was free to date. Here is an excerpt from his response. It is not pastorally wise to force people to stay in marriages that are not happy or good. The very fact that the church has a marriage tribunal indicates that there is a recognition of the reality that some marriages are judged to be not sacramental. While it is our responsibility to encourage and promote marriage as a sacramental permanent union, sometimes that does not occur. Felix knows that the church cannot force his wife to reconcile, but they could at least teach her that in their circumstances, divorce is immoral and a grave offense against nature, as the Catechism teaches in 2384. In St. John Paul II's 2004 address to the Roman Rota, he taught that, in accord with human experience marked by sin, a valid marriage can fail because of the spouse's own misuse of freedom. Felix could find no one to tell his wife that her interest in divorcing Felix could be sinful. He could find no one to tell her that their difficulties could be overcome if it were not for their refusal to struggle and make sacrifices, as taught by St. John Paul II in his 1988 address to the Roman Rota. Another husband I know petitioned his bishop's office seeking intervention for the diocese to help reconcile his marriage after his wife had abandoned him for no legitimate reason. Furthermore, he requested that if his wife would not reconcile, a decree of separation would be issued in recognition of the wife's unilateral decision to abandon the conjugal life. He received a 2-paragraph reply. The first paragraph described how the couple's pastor said the wife had no interest in addressing issues of reconciliation. In the second paragraph, the husband's request for a decree of separation was denied because the diocesan official thought that issuing a decree of separation would harm the rights of either party to petition for a decree of nullity in the future. In another case, a letter was written to a bishop by some people who were disappointed about a husband abandoning his wife. We'll call him Jack. Citing canon law and the Catechism, they requested a preliminary investigation and possible penalties, hoping to motivate the abandoning husband to reform. They also said that the husband should be denied communion if he obstinately perseveres in grave manifest sin, per Canon 915. Here are excerpts from the bishop who denied the request and referred to a letter he had written Jack earlier. The letter I wrote to Jack was a pastoral exhortation to encourage him to reconcile with his wife. There is no canonical penalty attached to his failure to respond. Jack could justly argue that he is being singled out for unjust treatment because an investigation of others who separate and divorce without permission from the legitimate church authority is not done. Jack would not be considered in manifest grave sin unless he was cohabitating with a woman or remarried. Even if he were to cohabit or remarried, neither is a delict. Divorce is a grave matter. Divorce, however, is not a crime in church law. I respectfully remind you that no one may unlawfully harm the good reputation of an individual or violate the right to protect his or her privacy, which is also an obligation in natural law. Your reference to Jack as an offender is presumptive, inflammatory, and lacking in charity. I cannot figure out why this bishop says that Jack would not be considered in grave sin unless he was cohabiting. This bishop appears to believe that marital abandonment and forcing divorce is not a grave sin. Moreover, the abandonment is manifest to everyone who knows the family well. It is true that in canon law, marital abandonment is not specifically listed as a delict or a crime. However, both the promoter of justice at the Apostolic Signatura and the secretary explained in 2005 how the bishop could proceed easily with an administrative penal process, even if a particular offense is not clearly identified as a delict. Cardinal Raymond Burke addressed the confusion about whether the denial of communion is a canonical penalty in his 2007 article, Canon 915, The Discipline, published by Gregorian University. He said, "There are other cases in which Holy Communion must be denied apart from any imposition or declaration of a canonical penalty. I propose that marital abandonment, where the other spouse has done nothing bad enough to merit separation, may well rise to the level wherein Holy Communion must be denied. Catholic officials regularly teach that those who are divorced are free to receive Holy Communion, and it is only those who are remarried without an annulment who may not receive Holy Communion." When that statement stands alone without clarifying the distinction between a faithful spouse and an abandoner, the Church appears to condone both parties in all divorce. An innocent spouse who has a morally legitimate reason for separation must be distinguished from a spouse who does something bad enough to merit separation for the other. After divorces have occurred, there are pressures everywhere encouraging people to give up on marriage, even in the church. For example, Irene's husband left her over 6 years ago and forced her through a no-fault divorce. She remains faithful to him, even though others tell her she should date and find a new spouse. In diocesan-sponsored programs, she has found virtually no support to remain faithful to her husband. In the United States, 2 popular programs, in fact, do the opposite. There is the collective assumption that the wrong spouse is chosen in the first marriage. Annulments are described as the pastoral healing practice that frees participants to date and seek another spouse, and annulments should be sought. It is presumed that everyone is free to date and find a new partner after certain emotional steps are completed. In Irene's example, though her husband is reneging on his marital obligations, they are married, and Irene cannot stop being married any more than I can stop being my son's mother. Irene does, however, feel supported by Cardinal Mueller, prefect of the Congregation of the Doctrine of the Faith. Listen to what he said in 2014 about the Church's role in healing wounds. "The Church, on the other hand, is called in this world to give the hope that enables us to endure life patiently with the wounds that we accumulate. It is neither lawful nor right, for example, for a layman or priest to tell someone who is suffering because she has been abandoned by her spouse, 'Well, now you can marry someone else.' That does not help, since the person is still wounded by the abandonment that she has suffered, and as we know, a wound is not healed simply by covering it up or by denying that it exists. One is not healed by merely trying to start over from zero. One is healed by offering up to Christ the wound that one has suffered, by fighting the good fight of the faith." I can only guess how challenging it would be to start implementing the canon laws on separation of spouses in regions where no-fault divorce practitioners have been controlling separation for decades. A starting point would be for priests and professed Catholic counselors to stop telling dissatisfied spouses that it is all right to divorce simply because you feel the love is dead or you have grown apart. Pastors could also widely publicize the availability of helps with high success rates for reconciling couples, like Retrovi, or focus on the Family's National Institute for Marriage or the Alexander House. Moreover, before a pastor recommends a marriage counselor, he could check whether the counselor would be willing to keep in mind the canon law on separation, including the need for the bishop's permission before filing for civil divorce. After a recent U.S. Supreme Court decision giving homosexual couples the right to enter civil marriage, Catholic priests might want to stop being officiants for state marriages altogether. In the United States, when parties exchange vows in the Catholic rite, the priest is simultaneously performing a marriage for the state. In essence, the state thereafter recognizes that the parties are civilly married, thereby leaving an innocent spouse and children susceptible to the maneuverings of a no-fault divorce system. Because the rights and obligations of Catholic marriage are so different to the rights and obligations of civil marriage, it may be time to officially separate the two. Parties who are canonically qualified to enter Catholic marriage could exchange vows in their rite of Catholic marriage, and only if they wanted the health insurance or tax benefits of having civil marriage, they could afterwards do so in a separate contract, completely distinct from Catholic marriage. Constitutional law expert Stephen Safranix says we could provide a better framework for Catholics to think about the type of marriage they are entering. An engaged couple could sign an agreement promising to abide by the canon law and designating the church as the arbitrator in any future disputes. And this agreement should be acknowledged by the civil court as a prenuptial agreement. If we are truly interested in implementing canon law on separation of spouses, experts in church law and moral theology must explore how justice and natural law should be applied in common cases of separation. It would not be hard to list, for example, 20 common reasons why marriages break up. We could include legitimate reasons for ecclesiastical separation decrees intermixed with grounds for invalidity of marriage when those are applicable. There are many questions that need to be answered so the faithful can receive instructions about the parameters of a separation plan that would be in accord with divine law. Consider, for example, a wife who wants to divorce her husband because she feels they have grown apart. Shouldn't the children keep in everyday contact with their father? Shouldn't the wife be expected to contribute her share to the maintenance of a home where the innocent husband can live with the children? In no-fault divorce decrees, the wife has the power to financially devastate her children by forcing the resources of two parents to be split between two households. Imagine a case where one party is faithful to marriage and did not cause a separation or divorce. Shouldn't that party be able to have the children live with him? Think about one who was responsible for a breakup. Picture a man who abandoned his marriage because he wanted to have a sexual relationship with a woman. In their case, we can presume that this man entered an invalid marriage because he simulated his vows and never intended sexual fidelity. After separation, if he wants to see the children, shouldn't he see them in such a way as to not disturb the normal household and community schedule of the children, where they live with their mother? No-fault divorce decrees commonly would order the children to spend overnight visits with this adultering dad and his new sex partner. Answers to these questions can show what is in accord with divine and even natural law. In conclusion, I emphasize the dire need for the Church to implement our own canon law about separation of spouses before anyone files for divorce in the civil form, especially in regions that have no-fault divorce. Canon 1692-2 has the bishop consider whether or not a civil decree would be in accord with divine law. When a professed Catholic abandons his or her marriage for no morally legitimate reason, I ask the Church to implement canon law and do what Pope Leo XIII described in our canon. Soften the evils of separation by such remedies and helps as are suited to parties' condition, and never cease to bring about reconciliation. Thank you.